25. Can federal grand juries issue valid indictments against illegal tax protesters? 83. No. The term illegal tax protester is a contradiction in terms. The First Amendment protects the right to petition the government and to express dissent, including protest against federal tax policies. Labeling such protest as illegal violates constitutionally guaranteed freedoms of speech, press, and assembly. 84. 85. Properly understood, the modifier illegal could apply only to the tax itself, not to the protest. Therefore, a so-called illegal tax protester is someone protesting what they believe to be an illegal tax, an act that is protected under the First Amendment and cannot, by itself, form the basis of a criminal indictment. What role does the UCC play in protecting protest rights? 85. The Uniform Commercial Code, U.C.C., specifically Section 1 to 308, reinforces the right to preserve legal objections by endorsing documents without prejudice or under protest. This reservation of rights doctrine protects individuals from implied consent to contractual obligations, including tax obligations, under duress or without full disclosure. 86. 87. Additionally, the U.C.C. enacted as municipal law under 77 Stat. 630, Public Law 88-243, extends procedural protections even in commercial and administrative matters. Its relevance further underscores that protest against financial obligations, including tax assessments, is not inherently criminal but is a form of protected legal dissent. 26. Do IRS agents ever tamper with federal grand juries, and if so, how? 87. Yes. IRS agents have been documented tampering with federal grand juries through a series of misrepresentations. These include falsely identifying themselves as lawful federal agents, mischaracterizing the legal status of the IRS, and presenting legally defective evidence. Such actions can constitute perjury, misprision of perjury, and fraud under 18 U.S. C. Sections 1621 and 1001. 88. 89. Agents also misuse the term income, presenting it to grand juries as everything that comes in, a definition not found in the Internal Revenue Code or upheld by controlling case law. This deliberate misrepresentation violates Section 43A of the Lanham Act, 15 U.S. C. Section 1125, which prohibits the use of false and misleading descriptions in commercial contexts, including federal investigations. What other illegal practices have been identified? 89. IRS agents have introduced evidence such as bank records without valid subpoenas or properly executed waivers of Fourth Amendment rights. Signature cards at banks are often used as blanket authorizations, despite their legal insufficiency. The Supreme Court in Brady v. United States, 397 U.S. 742, 748, 1970, emphasized that waivers of constitutional rights must be knowing, voluntary, and intelligent. 90. 91. There are also allegations that IRS agents offer cash kickbacks ranging from $25,000 to $35,000 to U.S. attorneys, federal judges, and even executive branch officials for securing criminal indictments. These alleged payments would violate the Anti-Kickback Act of 1986, 41 U.S. C. Sections 8701 et seq., and support the claim that the IRS operates as a federal subcontractor under 31 U.S. C. Section 1321A, 62, subject to dismantlement under RICO and antitrust law. 27. What is the kickback racket, and where can evidence of its existence be found? 91. The so-called kickback racket refers to alleged cash payments made to federal officials in exchange for indictments against individuals labeled as tax protesters. This scheme first surfaced through delegation tables in the Internal Revenue Manual, IRM, which outlined the administrative structure authorizing such payments. 92. 93. A lawful request under the Freedom of Information Act, FOIA, sought a certified list of all payments made under these provisions. The IRS response, signed by tax law specialist Mark L. Zoltan, acknowledged that most such awards were paid in cash and, consequently, not recorded in accessible systems. This admission raises serious concerns regarding transparency and corruption within federal enforcement. How did federal courts react to this evidence? 93. When this evidence was presented in a federal court proceeding involving a small Arizona business, U.S. District Judge John M. Roll obstructed all 28 pieces of mail submitted to the grand jury. This interference violated 18 U.S. C. Section 1702, which prohibits obstruction of correspondence, a federal offense. 94. 95. Judge Roll's actions appeared designed to prevent the grand jury from learning of the alleged kickback scheme. Despite the obstruction, defense counsel ensured the evidence reached the grand jury through alternative lawful means. The incident highlights systemic barriers to exposing institutional misconduct.